Good evening. Tonight, we are conducting an in-depth analysis of a series of monumental shifts within the Social Security Administration, changes that are directly impacting the monthly checks of millions of Americans. We are focusing on what many call the clawback crisis, the agency's aggressive efforts to recover benefit overpayments. For many low-income beneficiaries, receiving an overpayment notice is not just a bureaucratic hurdle. It is a catastrophic event that triggers immediate alarm and profound concern over their ability to cover basic living expenses. However, the landscape of Social Security debt has fundamentally shifted as of late 2024 and early 2025. One of the most critical developments is the implementation of new administrative waiver thresholds. Specifically, the SSA has significantly increased the level for these waivers from $1,000 to $2,000. This means that for overpayments totaling $2,000 or less, the agency will now presume the individual was not at fault and may automatically waive the debt upon request. The rationale behind this shift is twofold. First, the SSA recognizes that pursuing small debts often costs the government more in administrative resources than the value of the recovery itself. Second, there is a clear acknowledgement of the challenges faced during the COVID-19 pandemic, where office closures and communication breakdowns led to a massive spike in unintentional overpayments. As we begin this 15-part investigation, we will explore how these new rules, directed by the newly formed SSI Improvement Team, aim to simplify a notoriously complex system and protect the financial security of our nation's most vulnerable citizens. Defining overpayments and the $2,000 waiver threshold. To understand the current shifts, we must first define the core issue. What exactly is a Social Security overpayment? Simply put, an overpayment occurs when an individual receives more money in benefits than they should have been paid for a specific period. Once a final determination is made, this amount becomes a debt owed to the federal government. Historically, the process of recovering these funds has been rigid, often causing extreme financial distress for recipients. However, May 2024 marked a turning point with the expansion of the administrative waiver. The Social Security Administration has increased the threshold for these waivers from $1,000 to $2,000. Under this new policy, if the overpayment amount is $2,000 or less, the agency will now presume that the beneficiary was not at fault for the error. Crucially, for debts at or below this limit, SSA may process the waiver quickly over the telephone, removing the massive burden of completing the lengthy and complex Form SSA 632. This change is designed to prioritize efficiency, as pursuing small debts often costs more in administrative labor than the value of the debt itself. For millions of Americans, this $2,000 threshold represents a vital safety net, ensuring that minor reporting errors or agency delays do not result in a life-altering financial penalty. The pandemic legacy and revised reporting rules. The roots of many current overpayment issues can be traced back to the unprecedented challenges of the COVID-19 pandemic. On March 17, 2020, the SSA closed all local hearing and regional offices to in-person visitors. While most have since reopened, these closures created a massive communication gap. Beneficiaries struggled to report changes in income, address, or living arrangements, leading to a surge in unintentional overpayments. Recognizing these systemic failures, the SSA has revised its waiver process specifically for pandemic-related debts. If you face challenges reporting information due to the public health emergency, such as being unable to reach a representative by phone or the closure of your local office, you may be eligible for a waiver. The agency now encourages recipients to report any COVID-19 related obstacles that contributed to the overpayment. Furthermore, for the Supplemental Security Income or SSI program, recipients are reminded of their strict reporting responsibilities. Any changes affecting eligibility must be reported no later than 10 days after the end of the month in which the change occurred. This includes changes in earned income, marital status, or even the death of someone in the household. By modernizing the reporting process, the SSA aims to prevent the clawback before it starts, ensuring that the legacy of the pandemic doesn't continue to haunt the financial futures of the disabled and elderly. Shifting the burden of proof, new fault determinations. In a significant win for beneficiary rights, the Social Security Administration has fundamentally changed how it determines who is at fault for an overpayment. Historically, the burden of proof was often placed on the individual to prove they were blameless. However, as of late 2024, the SSA has shifted this assessment to be more neutral, balanced, and fair. Now, the agency will not find an individual at fault unless there is clear evidence that they intentionally made an incorrect statement, failed to furnish material information, or accepted a payment they knew was wrong. This neutral assessment policy requires SSA employees to consider an individual's specific circumstances, including their age, education, memory, and any mental or physical conditions. Linguistic limitations and lack of facility with the English language are also now formally considered. Most importantly, the SSA has identified 20 different circumstances where a beneficiary is now automatically presumed to be not at fault. These include situations where a person timely reported a change, but the agency continued to send unchanged payments, or cases involving minor children and legally incompetent adults. By shifting the burden of proof back to the agency, these new rules provide a powerful defense against aggressive debt recovery, ensuring that honest mistakes do not lead to financial ruin. Repayment caps and the 10% withholding protection. For those who do not qualify for a waiver, the fear of losing their entire monthly check to debt recovery is a common reality. However, new protections implemented in 2024 have dramatically limited the agency's power to claw back benefits. For retirement, survivor, and disability insurance, known as Title II benefits, the SSA has slashed the default withholding rate. Previously, the agency could withhold 100% of a monthly check if a beneficiary failed to respond to an overpayment notice, a practice that often led to homelessness. Now, the default withholding rate is capped at just 10% of the monthly benefit, or $10, whichever is greater. For supplemental security income, or SSI recipients, the standard withholding is generally 10% of the maximum federal benefit rate. Furthermore, if a 10% deduction still causes financial hardship, beneficiaries have the right to negotiate an even lower repayment rate, as low as $10 per month. The SSA has also extended the standard repayment time frame from 36 months to 60 months, allowing for smaller, more manageable monthly installments. Crucially, you do not need to fill out a complex financial disclosure form if you agree to a rate that pays back the debt within this 5-year window. These changes represent a compassionate shift toward ensuring that debt recovery never compromises a citizen's ability to pay for food and shelter. SSI resource limits, the $2,000 and $3,000 barriers. While we have discussed the $2,000 waiver threshold, it is equally important to understand the $2,000 resource limit, a rule that defines eligibility for the Supplemental Security Income Program. SSI is a means-tested program designed for those with extremely limited income and assets. To remain eligible, an individual cannot have more than $2,000 in countable resources. For a married couple living together, this limit is $3,000. What exactly counts as a resource? The SSA defines it as cash, bank accounts, stocks, or any real or personal property that you own and could convert to cash to pay for food or shelter. Resources are counted on the first day of every month. If your bank balance exceeds these limits by even a few dollars on the first of the month, you are technically ineligible for SSI for that entire month. This is a major cause of overpayments, as many recipients unknowingly save a bit too much or receive a small gift that pushes them over the limit. Furthermore, the agency uses a process called deeming, where a portion of a spouse's or parent's resources are counted as belonging to the applicant. Understanding these strict barriers is the first step in avoiding the accidental accumulation of debt that the SSA will eventually seek to recover. Excluded resources, protecting your home and car. Despite the strict $2,000 limit, many people are surprised to learn that their most valuable assets often do not count toward the SSI resource total. These are known as excluded resources. The most significant exclusion is the home you live in and the land it sits on, regardless of its market value. As long as it is your principal place of residence, it is safe from being counted as an asset. Additionally, the SSA allows for one vehicle per household to be excluded, regardless of its value, if used for transportation for you or a household member. Other exclusions include household goods, such as furniture and appliances, and personal effects like wedding rings. You can also set aside up to $1,500 for burial funds for yourself and your spouse, and own burial plots for your immediate family. Interestingly, certain types of financial assistance are also excluded permanently, such as pandemic-related disaster assistance and stimulus payments. Retroactive Social Security checks are also shielded for up to 9 months after receipt. By knowing which assets are protected, beneficiaries can maintain a stable life and even own a home or a reliable car without fear of losing their monthly support. The SSI Improvement Team and Modernization in 2026. In September 2025, a major initiative was launched to transform how the SSA operates, the SSI Improvement Team. Formed by Commissioner Bisignano, this team is tasked with making SSI processing more efficient and reducing improper payments. One of the most significant technological leaps is the full implementation of the Payroll Information Exchange, or PIE. Through PIE, the SSA can now receive monthly wage reports directly from payroll data providers for those who authorize it. This automated exchange helps prevent overpayments by ensuring that income changes are recorded in real time, rather than relying on beneficiaries to manually report their pay stubs every month. Furthermore, the agency has expanded its access to financial information tool to identify excess bank assets early, preventing large debts from accumulating over many years. The team has also simplified guidance for in-kind support and maintenance and clarified how employees should determine the market value of assets. By moving away from manual tasks and embracing automation, the SSA aims to reduce the reporting burden on recipients while ensuring that every payment is accurate and fair. This modernization is the agency's primary weapon in the fight against the overpayment crisis. ABLE accounts, saving without penalty. For individuals who became disabled before the age of 26, a limit set to expand to age 46 in 2026, there is a powerful tool to bypass the $2,000 resource limit, the ABLE account. Formerly known as a 529A account, ABLE programs are state-run savings plans that allow people with disabilities to save for their future without losing their SSI or Medicaid eligibility. The rules are incredibly generous. The first $100,000 in an ABLE account is completely exempt from the SSI resource limit. Even if the account exceeds $100,000 and SSI is suspended, the individual remains eligible for Medicaid. These funds can be used for qualified disability expenses, which include everything from housing and transportation to education, employment training, and even legal fees. Contributions are made with after-tax dollars, but the earnings grow tax-free. In 2025, the annual contribution limit is $19,000, with even higher limits for those who work. By using an ABLE account, a beneficiary can build a significant financial cushion far beyond the standard $2,000 barrier to maintain their quality of life and long-term security. Resource transfer penalties and the spend-down rule. A common mistake that leads to long-term SSI ineligibility is giving away money or assets to stay under the $2,000 limit. This is known as a resource transfer. If you sell a resource for less than its fair market value or simply give it away, the SSA can impose a transfer penalty. This penalty can result in being ineligible for SSI benefits for up to 36 months. The length of the penalty is calculated by dividing the value of what you gave away by your monthly benefit rate. For example, if Mr. Zepp sells a car worth $12,000 to his granddaughter for only $5,000, the uncompensated value of $7,000 is treated as a transfer for less than fair market value. Dividing $7,000 by a monthly benefit of $914 results in a 7-month period of ineligibility. However, there is a valid way to reduce your assets: the spend down. You can spend your excess cash on things you need as long as you receive fair market value in return. This includes paying off debt, buying clothes, or even making home repairs. The key is to keep all receipts and records to prove to the SSA that you didn't just give the money away to cheat the system. Workers' comp and public disability offset. For those receiving Social Security Disability Insurance, or SSDI, another complex layer can trigger a reduction in benefits: the workers' compensation offset. While private insurance or pensions do not affect your SSDI, disability payments from federal, state, or local governments can. The law is clear. The total combined amount of your SSDI and your workers' comp or other public disability benefits cannot exceed 80% of your average current earnings before you became disabled. If the total exceeds that 80% mark, the SSA will deduct the excess from your monthly Social Security check. For instance, if you earned $4,000 a month before your disability, your 80% limit is $3,200. If your combined benefits total $4,200, the SSA will reduce your check by $1,000 to stay within the limit. This reduction continues until you reach full retirement age or the other benefits stop. It is vital to report any changes in your workers' comp payments immediately, as an increase in those benefits could trigger a retroactive overpayment notice from the SSA. Whether you receive monthly payments or a large lump sum settlement, the 80% rule remains a critical factor in your monthly financial planning. Inheritances and court awards, the timing trap. A sudden windfall, such as an inheritance or a court settlement from a car accident, can be both a blessing and a bureaucratic nightmare for SSI recipients. The SSA treats these payments under a timing rule that often leads to overpayments. In the month you receive the cash or property, it is counted as unearned income. In every month after that, any remaining funds are counted as a resource. Let's look at the case of Ms. Lee, who received a $10,000 car accident settlement in March. For the month of March, she is ineligible for SSI because the $10,000 is counted as income. On April 1st, because that money is still in her bank account, it is counted as a resource, putting her well over the $2,000 limit. If she doesn't spend down the money by the end of June, she remains ineligible for all those months. Furthermore, if you decline or disclaim an inheritance to stay eligible for SSI, the SSA treats this as a resource transfer and will penalize you with a period of ineligibility. The agency has recently clarified these rules, providing examples of when they might not count the full amount, such as deducting legal fees or medical expenses necessary to obtain the award. Navigating these windfalls requires careful planning and immediate reporting. The waiver process and financial hardship. If you receive an overpayment notice and believe it wasn't your fault, you have the right to ask for a waiver. As we've noted, for debts of $2,000 or less, this can often be done over the phone. For larger debts, you must submit Form SSA 632. To win a waiver, you must prove two things. First, that the error was not your fault, and second, that paying it back would either defeat the purpose of the Social Security Act or be against equity and good conscience. What does defeat the purpose mean? Essentially, it means you cannot afford to pay the money back because you need all your income for basic living expenses. The SSA now presumes you have a financial hardship if you already receive means-tested benefits like SNAP, food stamps, TNF, or Medicaid Part D extra help. They also presume an inability to repay if your household income is at or below 150% of the federal poverty level. If you can show that you relied on the incorrect payments to change your financial position for the worse, like signing a more expensive lease, the SSA may find it unfair to recover the debt. During the waiver request, all collection efforts must stop until a decision is made, providing you with much-needed breathing room. Working while disabled. The SGA and ticket to work. The SSA actively encourages beneficiaries to return to work, but the rules are strict to avoid over-earning overpayments. For SSDI recipients, the trial work period allows you to test your ability to work for 9 months while receiving full benefits, regardless of earnings. In 2026, a trial work month is any month you earn over 1,210 hours. After those 9 months, you enter the extended period of eligibility, where your benefits stop for any month you earn more than substantial gainful activity or SGA. In 2026, the SGA limit is $1,690 or $1,230 if you are blind. For SSI recipients, there is no trial work period. Instead, the SSA reduces your benefit by 50 cents for every dollar you earn over the first $85. However, you can use work incentives to lower your countable income. For example, impairment-related work expenses, like the cost of a specialized van, a job coach, or counseling, can be deducted from your earnings before the SSA calculates your benefit. There is also the Ticket to Work program, which offers free vocational rehabilitation and job search assistance. By utilizing these programs, you can transition back to the workforce with a safety net that protects you if your medical condition worsens. Conclusion: navigating the future and due process. As we conclude our investigation into the new Social Security clawback rules, The most important takeaway is the power of information and due process. The shift to a $2,000 waiver threshold and the 10% withholding cap are major steps toward a more humane system. However, the responsibility to report changes remains with the individual. Whether it is a change in address, income, or resources, you must tell the SSA immediately, typically within 10 days for SSI, to avoid the trap of overpayment. If you receive a notice you disagree with, do not ignore it. You have 60 days to file an appeal using Form SSA 561. Most appeals can now be filed online, and the SSA provides free interpreter services for those who need them. Remember, the newly formed SSI Improvement Team is working to modernize the agency, but they rely on your cooperation and permission to use tools like the Payroll Information Exchange. By staying informed, utilizing ABLE accounts, and understanding your rights to a waiver, you can protect your financial dignity. The clawback does not have to be a catastrophe. With the right tools and a proactive approach, you can navigate the Social Security system with confidence and security. For more information, visit ssa.gov or contact your local office today.